Federal immigration enforcement has fundamentally changed the way it operates in New York. And the people being caught in its net are not who most New Yorkers assume. When people hear the phrase immigration enforcement, they picture undocumented immigrants hiding from authorities. The reality in 2026 is far more unsettling than that. United States citizens are being detained for hours, sometimes days, because of simple database errors. Legal, permanent residents who have lived, worked, and raised families in this country for 20, 30, even 40 years are suddenly losing their status over traffic violations they didn't know carried any immigration weight. Green card holders are being placed in removal proceedings for criminal convictions that happened before many of their children were born. This is not speculation. This is not fear-mongering. These are documented legal patterns unfolding right now across New York. The intersection of New York state laws and federal immigration enforcement has created a legal minefield. And that minefield does not only trap people who entered the country without documents. It traps legal residents. It traps visa holders. It traps naturalized citizens. It even catches the U.S.-born family members of immigrants who find themselves tangled in proceedings they never anticipated. If you live in New York, work here, pay taxes here, or simply have family members who do, these changes have the potential to affect your life regardless of where you were born or how long you have been here. What we are going to walk through today are 10 specific legal mechanisms, real enforcement tools, real statutory traps, and real bureaucratic failures that are actively putting New Yorkers at risk in 2026. Each one is grounded in actual immigration law and documented enforcement patterns. Each one carries devastating financial and personal consequences that most people never see coming until it is far too late to avoid them. So let's start from the bottom and work our way to the situation that is catching the most people off guard right now. In 2019, New York passed what became known as the Green Light Law. The intention was straightforward and compassionate. Allow undocumented immigrants to obtain standard driver's licenses so they could drive legally, get to work, take their children to school, and participate in daily life without the constant fear of being pulled over without a license and immediately flagged to immigration authorities. The law specifically included language prohibiting the Department of Motor Vehicles from sharing license information with federal immigration authorities unless compelled by a valid court order or warrant. For a brief period, it genuinely felt like a protective measure. But here is what has happened since then, and why that protection has eroded in ways that the law's authors did not fully anticipate. Federal authorities have become increasingly aggressive about obtaining warrants and subpoenas for bulk DMV data. They are not targeting one individual at a time. They are requesting comprehensive records on every person who obtained a license through the Green Light Law's provisions. Because the New York DMV is legally obligated to comply with valid federal court orders, those requests get fulfilled. The database that was built to help people drive legally has effectively become a registry that immigration enforcement can access, a registry that includes full legal names, home addresses, photographs, and dates of birth. The consequences extend well beyond the license holders themselves. If you are a United States citizen or a lawful permanent resident who helped a family member or friend apply for a green light license, your information may also appear in associated records. Family members who share an address with the license holder appear in database searches. Immigration authorities are able to cross-reference DMV data with auto insurance records because New York requires all drivers to carry insurance, and insurance companies report policy information to the state, building out detailed target lists that include vehicles, addresses, and household compositions. For the people who went to the DMV in good faith, believed their information was protected, and built their daily lives around the assumption that they could drive to work without fear, discovering that federal agents may now have access to all of that information is genuinely traumatizing. Some have stopped driving entirely rather than risk a traffic stop that reveals their identity. But driving without a valid license in New York is a criminal offense, which means these individuals are being pushed toward breaking a different law in order to avoid immigration consequences. The financial damage alone, license fees paid, insurance premiums invested, vehicles purchased in reliance on having a valid license, can easily reach thousands of dollars for families who can least afford it. New York City's sanctuary city policies are real, and they do provide meaningful protection in many circumstances. But they are not absolute, and the gaps within those policies are large enough that real people are being harmed. Understanding what the policies actually say, rather than what people assume they say, is critical for anyone who is not a U.S. citizen living in the 5 boroughs. NYPD does not generally honor civil immigration detainers. Requests from ICE asking local police to hold someone beyond their scheduled release date so federal agents can take custody. That part of the sanctuary policy functions roughly as intended. But here is where the gray area opens up. NYPD will share information and cooperate with federal immigration enforcement for individuals with certain criminal convictions. The definition of what qualifies as a serious conviction has expanded in ways that are not widely publicized. DWI convictions, domestic violence arrests, even arrests that did not result in conviction, and certain theft offenses can now result in NYPD notifying ICE of an individual's release from custody. The timing of this matters enormously. When NYPD arrests someone who is not a U.S. citizen, the system automatically runs their information through databases that flag immigration records, even if the criminal charges are eventually dropped completely, or even if the person is found not guilty at trial. The arrest itself has already created a record that immigration authorities now possess. The arrest happens Friday night. The person is held over the weekend. By the time the paperwork moves and the person is scheduled for release Monday morning, ICE knows the location and release time. The detainer is not honored, but the communication has already happened. ICE simply waits outside. For lawful permanent residents, this dynamic creates a financial nightmare that most people never anticipate when they are first arrested. A criminal case that gets completely dismissed because the charges were wrong, or the evidence was insufficient, or the prosecution declined to proceed, might still cost $5,000 to $10,000 in criminal defense attorney fees. And then the immigration consequences of that same arrest, the arrest itself used as a character issue in future immigration proceedings, can require another $10,000 to $20,000 in immigration attorney fees to properly address. An arrest that led to no conviction and no criminal record still costs $30,000 by the time the legal dust settles. JFK, LaGuardia, and Newark airports are federal property. The moment you step into the international arrivals area, you are not in New York. Legally speaking, you are in a jurisdiction where the sanctuary policies, the state-level protections, and the local legal landscape simply do not apply. Customs and Border Protection officers operate under a set of authorities that are broader and more discretionary than almost any other law enforcement context in the United States. And the consequences of an encounter with CBP at the airport can be immediate and severe in ways that a routine traffic stop or even an arrest in the city cannot match. For green card holders, the exposure at airports is particularly significant. If you are a lawful permanent resident who traveled outside the United States for more than 6 months, you face serious questions about whether you intended to abandon your permanent residence. CBP officers have the authority to determine on the spot that you have abandoned your residence, even if you own property in New York, even if your spouse and children are U.S. citizens living here, even if your entire professional and personal life is here. They can confiscate your green card at the airport and initiate removal proceedings without any prior notice or judicial involvement. This happens. It is not a theoretical worst-case scenario. U.S. citizens are not immune to these encounters. Citizens with names that are common in countries with high rates of immigration violations, citizens who speak English with foreign accents, citizens who travel frequently to certain countries are routinely pulled aside for secondary inspection. In that secondary inspection area, database errors surface in real time. Your name might closely resemble someone with an immigration flag on their record. Your date of birth might have been entered incorrectly in a government system years ago. A travel document from a previous trip might not have been properly closed out in the records. These errors result in detention that can last hours, sometimes much longer, while agents attempt to verify your identity and status. There is no compensation available. If CBP holds you for 6 hours due to a database error and you miss your connecting flight, lose your hotel reservation, and miss an important meeting, you have no legal recourse for those losses. The federal E-Verify system and Social Security number verification databases contain errors. This is not a contested point. Government audits have documented measurable error rates in these systems for years. What is not widely understood is what those errors cost regular working people when they surface during employment verification. If you are fully authorized to work in the United States, a citizen, a lawful permanent resident, a visa holder with work authorization, but the electronic verification system returns a mismatch on your information, your employer is legally required to place you in a tentative non-confirmation process. You have 8 business days to contact the Social Security Administration or Department of Homeland Security to begin resolving the discrepancy. During those 8 business days, your employer may legally suspend you from work without pay. Many employers do exactly this, not because they doubt you specifically, but because they have liability concerns about continuing to employ someone whose verification status is in question. The causes of these errors are mundane and common. Women whose Social Security records do not yet reflect a name change after marriage. People with hyphenated or compound surnames that get entered differently across different government systems. Individuals whose work authorization documents were processed with a minor clerical error that no one caught at the time. None of these situations involve any wrongdoing by the worker. All of them result in the same crisis: no income, mounting bills, and a bureaucratic process that does not move quickly. Resolving a verification error typically requires visiting government offices in person, submitting supporting documentation, and waiting for multiple systems to update and sync. For someone living paycheck to paycheck, which describes a significant portion of New York's workforce, losing even 2 weeks of income is not an inconvenience. It is a financial emergency. Rent falls behind, credit card payments are missed, utilities get shut off. The credit damage from that 2-week gap can persist for years. There is a legal concept in immigration called the public charge determination. It is the government's assessment of whether an immigrant is likely to become primarily dependent on government assistance. This concept has existed in immigration law for a long time, but the way it is applied and the benefits it covers have shifted in ways that are creating an impossible situation for tens of thousands of lawful residents in New York, legal permanent residents who have lived in the United States for years, people who pay taxes, who work legally, who have built lives here, face a genuine dilemma if they lose a job or encounter a medical crisis. Using Medicaid, SNAP food benefits, housing assistance, or cash assistance programs can be counted against them in green card renewals, citizenship applications, and visa extensions. The benefits exist. They are legally available to these individuals. But accepting them carries immigration consequences that can affect their ability to sponsor family members for green cards or can be used as evidence against them in future immigration proceedings. The human cost of this dynamic is serious and documented. Families are going without sufficient food rather than risk the immigration consequences of accepting SNAP benefits. Individuals are delaying medical care, sometimes seriously needed medical care, rather than use Medicaid coverage they are technically entitled to. For elderly lawful permanent residents who have reached retirement age and may need nursing home care funded through Medicaid, the calculus becomes especially painful. Accepting the care they need could affect their eventual citizenship application. Refusing the care they need means paying out of pocket for services that can cost several $1,000s per month. For a senior on fixed Social Security income, those out-of-pocket medical expenses can consume every dollar they receive, leaving nothing for basic living expenses. This is the trap that surprises people most because it starts so small. A speeding ticket, a minor moving violation, a failure to signal. These are the kinds of infractions that U.S. citizens handle by paying the fine online and moving on with their day. For non-citizens, particularly for lawful permanent residents and visa holders, the same ticket creates a permanent record that immigration authorities review during any future interaction with the system. Multiple traffic violations within a relatively short period can be characterized as a pattern of disregard for the law, which then becomes a factor in discretionary immigration decisions. When you apply to adjust your immigration status, renew a visa, or apply for citizenship, USCIS reviews your complete legal history, and that history includes traffic violations. Certain traffic offenses carry dramatically more weight than their ordinary criminal significance would suggest. DWI has been classified as a crime involving moral turpitude in some federal circuit courts, which can make a lawful permanent resident deportable. Reckless driving, leaving the scene of an accident, and driving with a suspended license are all viewed negatively in immigration proceedings in ways that most non-citizens are never warned about. The particular cruelty of this trap is that the immigration consequences are almost never disclosed at the moment they attach. When you plead guilty to a speeding violation in New York traffic court, the judge tells you the fine and the points. No one tells you that you have just created an immigration record. Many people plead guilty to minor violations specifically to avoid taking time off work for a court appearance, a perfectly rational decision for a U.S. citizen, and a potentially life-altering mistake for a non-citizen. For young people who were brought to the United States as children and currently hold DACA status, the stakes are even higher. DACA requires recipients to maintain a clean record. 3 traffic tickets within 2 years can be deemed a pattern of violations significant enough to disqualify someone from DACA renewal. A speeding ticket that cost $75 turns into a $5,000 immigration case before it is resolved. Federal immigration law contains a category of offenses called aggravated felonies. The name is misleading in a very important way. An aggravated felony under immigration law does not have to be an aggravated offense under state law. It does not even have to be a felony under state law. A theft offense where the sentence imposed, even a sentence that was fully suspended and never served, reaches 1 year or more qualifies as an aggravated felony for immigration purposes, regardless of how New York criminal law classifies it. Certain drug offenses and fraud convictions follow similar logic. The immigration classification bears no necessary relationship to the state criminal classification. ICE is now systematically reviewing old criminal records and initiating deportation proceedings against lawful permanent residents whose decades-old convictions were either not deportable offenses at the time or were handled with the understanding that they would not carry immigration consequences. A man who came to the United States as a child, received his green card through family sponsorship, made a serious mistake at age 20, served his sentence, and then lived completely lawfully for the next 40 years, can find himself in removal proceedings at age 60 because of that conviction. The criminal justice system treated his debt to society as paid. The immigration system does not recognize that payment. What makes this particularly devastating is that attorneys who represented these individuals at the time of their criminal cases 15, 20, 25 years ago may not have warned them about immigration consequences because the law has changed since then. Offenses that carried no immigration consequences in the year 2000 became deportable under legislation passed in subsequent years. People are, in effect, being punished retroactively for convictions that did not carry these consequences when they occurred. Defending against removal in these cases requires immigration attorneys whose fees range from $10,000 to $30,000 for contested proceedings. If the person is detained during the proceedings, and which ICE increasingly pursues, they lose their income for the entire duration of the case, which can stretch for a year or more. Unlawful presence in the United States triggers automatic bars to future legal immigration. And the way these bars operate is far more complex and far less forgiving than most people understand until they are already trapped by them. If you entered the United States lawfully on a visa, a tourist visa, a student visa, a work visa, and you remained in the country beyond your authorized period of admission, you accumulated unlawful presence. Once that unlawful presence reaches 180 days, leaving the country triggers a 3-year bar on returning legally. Once it reaches 1 year, leaving triggers a 10-year bar. These consequences attach the moment you depart, not the moment you entered unlawfully, not the moment authorities discover you, but the moment you leave. The situations that create these bars are often situations where the person genuinely did not understand they had overstayed. Someone enters on a tourist visa, falls in love, and marries a U.S. citizen and assumes, reasonably but incorrectly, that marriage to a citizen immediately resolves their immigration status. It does not. They remain unlawfully present until an adjustment of status application is properly filed and approved. If they need to leave the country for any reason before that adjustment is complete, a family emergency, a business obligation, anything, leaving triggers the bar. They cannot return for 3 or 10 years, even though their spouse is a citizen and their entire life is in New York. For people who have lived in the United States for many years after an overstay and are now in a position to regularize their status, the available options are extremely constrained. Waivers of the bars are possible, but require demonstrating that a U.S. citizen or lawful permanent resident, spouse, or parent would suffer extreme hardship if the person is barred from returning. Financial hardship alone, even the genuine financial devastation of a family losing its primary earner, typically does not meet the standard. The hardship must be something beyond what any family separated by immigration enforcement would experience. Attorney fees for waiver applications range from $5,000 to $15,000 with no guarantee of approval. The unlawful presence bar is perhaps the single most common immigration trap in New York, and it catches people who thought they were doing everything right. This is the scenario that immigration attorneys find most heartbreaking to explain to clients because it involves people who were trying to do exactly the right thing. Applying for United States citizenship is logically something a lawful permanent resident should eventually do. It confers the full and permanent security of citizenship. It eliminates the vulnerability of green card status. For most applicants, it is a straightforward process that takes a year or two and ends with a ceremony and a passport. But USCIS reviews your entire immigration history when you apply for citizenship, not just your recent history, your entire history going back to the original application that brought you into lawful status. If that review surfaces anything that should have made you inadmissible or deportable at any point, an old criminal conviction that was not properly disclosed, a period of unlawful presence that was not properly addressed, a statement on a previous immigration form that turns out to be inaccurate, even if the inaccuracy was unintentional. USCIS can deny your citizenship application and simultaneously refer your case for removal proceedings. You applied to become more secure. You ended up in deportation court. The cruelest dimension of this trap is the counterfactual. If you had simply never applied for citizenship and remained a lawful permanent resident indefinitely, you would likely have been fine. The dormant issues in your immigration history would have stayed dormant. By initiating the citizenship review process, you triggered an examination that exposed vulnerabilities that enforcement was not actively pursuing. For elderly lawful permanent residents who have been advised for years to apply for citizenship to protect their status, this changes the calculus entirely. If there is anything at all questionable in the immigration history, anything that might look different in hindsight, anything involving an old conviction, any gap in records, the risks of applying must be carefully weighed against the risks of remaining a permanent resident. Removal proceedings initiated after a citizenship denial are extremely difficult to defend against. USCIS has already determined you are deportable. The burden shifts to you to prove otherwise, and most applicants in this situation are ultimately deported to countries they have not lived in for decades. Immigration attorney fees for defending against removal in these cases range from $20,000 to $50,000 for complex situations. Every 10 years, lawful permanent residents must renew their green cards. For most people, this is a bureaucratic process. Fill out a form, pay a fee, submit biometrics, wait for the new card to arrive in the mail. But increasingly, green card renewals are triggering comprehensive reviews of the original application that granted the green card in the first place. And those reviews are discovering issues, sometimes real issues, sometimes the result of incorrect information provided by immigration consultants or family members handling paperwork that result not in a renewed card, but in removal proceedings. The most common triggers for these problems involve the circumstances under which the original green card was obtained. Marriage-based green cards, where the marriage is now alleged to have been fraudulent. Employment-based green cards, where the sponsoring job is determined not to have existed as described at the time of the petition. Family-based green cards, where the underlying relationship is questioned. The applicant for the renewal may have had absolutely no knowledge of any fraud. They married genuinely, or they trusted an employer who handled the petition, or they relied on family members to navigate paperwork in a language they did not fully read. None of that matters in the legal proceedings that follow. If USCIS determines the green card should never have been issued, they revoke it. The statute of limitations on immigration fraud is extremely long. Issues from 20 or 30 years ago are fair game. When a green card renewal is denied and removal proceedings begin, the person immediately loses their work authorization. They cannot legally work while the case proceeds through immigration court, which is a process that can take anywhere from several months to several years, given current court backlogs in New York. Their income stops, their bills do not. Families that were financially stable enter poverty during the proceedings. Many are forced to spend retirement savings, liquidate home equity, and exhaust every financial resource they have built over decades in order to fund their legal defense. For seniors who obtained their green cards in the 1980s or 1990s, often relying on immigration consultants whose practices were questionable by today's standards, the discovery of problems during renewal is genuinely devastating. They are being told that their entire legal status in the United States, the foundation of their entire adult life in this country, was built on paperwork that contained errors or fraud they never knew about and never intended.